Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Let me put my whole self on here. Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. This is what we're going to talk about on today. We're going to talk about Rodney Jones versus Sean Combs. You guys remember Rodney Jones, don't you? That was one of the first very colorful lawsuits that we went over. Y'all probably don't forget about him because the Busby has taken over the airwaves. But no, Rodney Jones' case is still going on, and this judge had a lot to say up in this here memorandum and opinion. So what I want you guys to do as you come in here, make sure that you hit that like button. Subscribe to the channel if you have not done so already. And I miss you guys. I hope you guys have been doing good and all of that. All of that good stuff. And yeah, I've been, working real hard. And then every now and then I did do a membership live on Friday. So if you have not seen it, make sure after we get off of this live, you go over there and you can watch that if you are a member. If you are not a member, you may want to consider joining the membership. And I'm sure one of the mods, when they come in, will probably put it in the bio. Okay. What have I been doing? I've been working and been on TikTok. Y'all see this? Where them fans at? Where them fans at? I was like, I need to stay off TikTok because now I done went and got a fan. Y'all see that? I was like, I don't know what baby just. Why am I doing this dance? It's just on. So every time I'm scrolling, somebody is doing this darn dance. And so I need a vacation. I need a vacation. Oh, boots on the ground. Where them fans at? Oh, boots on the ground. All right, I got to get serious here. This is just the intro. That's why I'm doing that right now. I'm letting people get a chance to come in and to get settled in. Again, make sure you hit the like button on your way. And I just want you guys to know what I've been doing. You know what I'm saying? I've been working and I've been line dancing and I've been ordering fans. Okay, that's what I've been doing. So what have y'all been doing? That's what we do in Detroit. A lot of these songs where you see on TikTok where people are doing new routines too, we did like back in the day, and they were way more complicated. So all of this little cutesy stuff that they're doing, it's like, of course not this Boots on the Ground. That is a new song. But like if you come to Detroit and you go to the clubs, to the Tamia line dance, we knew that a long time ago. We probably have the ballroom hustle. We ballroom a lot here. So there were like clubs. I know when I was in my early 20s where you had clubs where they had ballrooming, like that's all they did. Then most of our clubs would have, like, before it got late, they would have somebody that would come in and they would teach you how to do a lot of the hustles. We call them hustles. And they would teach you to do a lot of the hustles or whatever. But yeah. So watching it on TikTok, I really never really was on TikTok like that. I will post videos every now and then, but more than not, people would just send me a bunch of videos and I would just go try to, after a while I click on because I got 1,000 of them in my DMs. And so that's what made me be on TikTok. And this the last couple of weeks because they've been so busy. That was like my distraction. And so that's how the fan came about. I was like, I want my own fan. You know what I'm saying? You said you still trying to learn the Tamia hustle. You know what's funny? Like Dev was working, he was doing security some couple years back at a club. And he was talking about the like how they play the Tamia over and over again. He was like, I hate that song. They play it over and over and over and over and over again. And I had never really done much of it like in front of Dev. Like I'm saved and sanctified. You know what I'm saying? So when he put the song on, he was like, this song right here. And I just started doing the hustle, the Tamia. He was like, how you learn that? I was like, that's all we did at the clubs. We didn't like, either you had your basic two-step, if the guys was real cool, or you knew like whatever dance was affiliated, whatever hustle was affiliated with the songs. And Tamia was like, the Tamia hustle was one of them. So yeah, he was all shocked. Like, how you know that? I'm like, I could literally just watch one and pick it up. Like it's so many times where if it was new and I just went to the club or whatever, I would just pick it up because that's kind of like what we did. Everything was routines. We was in elementary school. We all had like little routines and stuff we did with our homegirls. Like everything was about picking up routines or whatever. So yeah, little known fact about me. You say, yeah, the Tamia dance is over 10 years old. Yeah, but they be making it seem like it's new. Like nothing, like a lot of this stuff is old. Like I said, it's one hustle that used to be very, very hard. I can't think of the name, but I just started seeing it again, and they don't do it anything like how we did it. But it's a lot simpler, but they didn't do it like how we did it back in the day. So it's cool to see some of these young people that are trying to vibe out or whatever with this. So yeah. But anyway, you said I used to be like that, but these new ones, man, I can't get them. They're basic. Honestly, it's just they add more. Everything got a body roll to it now. Like everything they dance and they got to throw a little twerk in it. Ours used to kind of be like two-step this way, two-step that way, spin around. It looked difficult, but it was, 1, 2, 1, 2, 1. Like you turn around and you knew all the steps or whatever. And them, they do it in ways that make it look complicated, but it's really not. If you really look, they're just adding all this extra wiggle and this extra but the steps really, if you just follow the steps, it's not that bad. But when you start looking at all the extra stuff they doing, the pop and all of that, especially if you are age, you looking like, I ain't doing that, my body can't do that no more. So that's kind of what the difference is. But yeah. No, you're not old. I'm telling you, it's the way. If you get the basics of it, then I'm sure you'll be fine. It's just they start doing stuff like it's these twins that I seen that were doing the line dancing, and they just end up showing up everywhere. A lot of those steps, and they like got whistles in their mouth and stuff, and I'm like, what is this? And then they just doom 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 doom. So yeah. But it's not that hard. Okay, let me speak to, hey, Ray Bishop. Good to see you. Hope you are doing well. Best way possible. Good to see you. I am so tired. You guys probably can hear, but I had to go live because it's definitely been a while. If you're just coming in, we're just discussing. I got my fan. Y'all see that? It has law intellects on it. So if I ever go out, I'm gonna record myself and I'm gonna come on here and I'm gonna show y'all when where them fans at. I'm gonna show y'all when I actually use this in public. I'm gonna videotape it. But right now, you guys are the first to see my family. Crystal said it. Oh, thank you so much, Dr. Mac. Crystal said, right, they annoy me. They had a. I'm like, oh my gosh, this is different, and you have to embrace, try to embrace the new generations because our parents probably looked at our music and said it was trash too. Like, that's kind of like, y'all don't know about that. You know how your parents and your grandparents used to say that, or your aunts and your uncles. And now I look at it and I'm like, this is not music. What is this? This is not music at all. But yeah. You said we need to sing. I need to sing you one. Yeah, I have to see about that. If enough of you want one, then maybe I will. But I was just literally this whole creation was just so random. When I got it, that was just part of me trying to avoid doing work. And I was like, oh, it'd be nice if I had my own fan. So I just designed it, and then I had somebody do it, and that was it. Yeah. So anyway, what we are here for on today is to talk about Diddy. Okay. It's been a lot of things that have happened with the Diddy cases. One of those we discussed in the membership, which is crazy to me because I've had local people in Michigan reach out to me about this guy, Derek Smith Cardello-Smith. And I went into details about him and kind of his litigious history and how he also has a history of forging documents. So it trips me out that I literally have local people here that's like, Pam, did you see this or what? I've gotten it a few times. So I don't want nobody to get offended if you're one of them, if you're in the chat or you're watching. But I did remember I followed that case when it was first filed against Diddy in Adrian, Michigan, and then he filed a similar lawsuit in Monroe, Michigan. During those times, it was like he ended up getting a default in Adrian because he went before the judge, said he served Sean Combs, actually was able to get an injunction against his properties and everything, saying that he served Diddy and got a default. So then, because it was filed in Michigan, one of our Michigan attorneys, of course, had taken over the case and represented Diddy in limited purposes for this default. And so what he did was he did the hearings, and I have the videos of that. So if you guys haven't seen that, then maybe I'll attach it to the end of this video since I'm talking about it so you can have easy access. But in that case, it was very interesting because the attorney that represented Diddy was like, he never was served. And they were able to show where some of the stuff looked like it was forged or doctored. And what they did, for those that didn't know the outcome of that, is they removed the case to federal court. So that case went to federal court. And then once it got removed to federal court, Diddy's attorney moved to dismiss that action. The court and asked for sanctions. The court granted their motion to dismiss that case against Diddy in January. And then cautioned him that this is your warning, because he's been warned in other courts, I believe, but this may have been the first time in the Eastern District of Michigan that he's been warned, because he has a history of filing multiple lawsuits. He sued everybody. Like, he's in prison right now. He sued JPay, which is the email system they use. If you guys don't know, he's filed habeas petitions over and over again. He helps a lot of other people. I've had clients that have literally called me about stuff that he said and lawsuits he allegedly filed that they wanted to be a part of. I'm like, so he even has a lot of people that he helps in prison because he comes across articulate and very, very smart when it comes to the law. Like, he knows the rules and all of that. But the problem just is it appears, and the judge said it in an order, so this ain't nothing that I'm saying what was in the order, that it looks like some of the documents, the math don't math. Like, some of the stuff is not accurate, because this attorney contacted some of the people who affidavits that he allegedly got, and they were saying they didn't sign them and things of that nature. And then it was like an issue with the mailing. It was a lot with this guy, right? So what he did was, after the court dismissed the case, they told him, we're giving you a warning and we're cautioning you not to continuously file these cases. So what he did was, almost immediately after, not immediately, but maybe a few weeks ago, he filed a motion to reconsider. And when he did it, he filed an affidavit from some judge, not a judge, an officer who he's alleging is basically admitting that they falsified and fabricated evidence against him, because he's in there for grape, right? Y'all picking up what I'm putting down. So that's what he's in there for. So he alleges that this police officer did an affidavit and admitted that he set him up. He also had an affidavit from a prosecutor, who I believe she is actually still a prosecutor over there, saying basically she was forced to do all of this stuff, and that was forced to lie on this guy, and everything was fake, and it was money involved, just all type of just craziness, right? And so this was after the case has already been dismissed, that he filed these affidavits. Subsequently, he also filed a habeas saying he should be released from prison based on this affidavit. So he attached the affidavit and filed a habeas. He also filed a brand new lawsuit against Diddy, which is what people were talking about, and making all these accusations and throwing in J-Lo. I think he threw in our prosecutor here, just all type of stuff. So I didn't really talk about it. First of all, some of these affidavits are people, again, that are still like working. And I would be pissed if I was a lawyer and somebody was making affidavits. Basically, in the affidavit, it's like she's admitting to committing crimes or something, is how this affidavit is written. So no, it wasn't anything. Again, I talked about it a little bit because somebody brought it up in the membership, and people are like, why aren't more people talking about this? Listen, I sued the police here. You guys know I've had lawsuits and issues with the prosecutor's office, other small cities or whatnot in Michigan. So I don't have a problem. And yes, I've had cases with falsified information. I've had a snitch ring case where they were, at one point in Detroit Police Department, they would have professional snitches that would just say, get your discovery, and basically say, oh yeah, he confessed to me. So I'm not one to be like pro the Detroit Police Department didn't do it, or that the prosecutors didn't do it. But when it comes to this guy, like, I want to win fair and square. Like, I don't win based on like just I'm throwing and just want to believe everything. I'm not one of those people. I told you guys, we've had that over here where I say sometimes when you don't like people, you want to believe everything bad about them. I'm not like that. When I go against these people, I have legit causes of actions that I file. So no, I don't just want to hang on to anybody that got something bad to say about the Detroit Police Department, because obviously there's some good too. Because if I was in DPD and like in Detroit and I was in distress, I'm calling them. So it's like, I call them if I need help. So no, all of them are not bad people. And the prosecutors, there are people that really are. I've had some great prosecutors that when I showed them, look, this video showed the opposite, and they've dismissed cases. So you don't always have the ones that just want to win at all costs. So I always, if it's true, I'm gonna talk about it, or I believe it's true. But if it's not, I'm just not even gonna keep perpetuating that lie. I'm not gonna do it. So that's that whole Cardello case. I don't think I'm gonna look it up real quick before we start talking about Rodney. Make sure y'all hit the like button and subscribe as you come in, so we can somehow get back in this good algorithm. Let me see. I want to see if the judge has said anything on that Derek case, but I mean, it makes for good video. I've seen one chicks that's just been going viral talking about it, but I'm just not, like, I know that he just does stuff. Okay. So I know he just does stuff, but this is the January 20th. Yeah, it was closed January 22nd. No, he hasn't. This was March 19th, the last thing he filed, motion to vacate. He's trying to vacate the order. So his case against Sean Combs, for those of you that don't know, the one that had started in Adrian, it was actually dismissed, and he sued. Let me see all the people that he sued on this one. It was already dismissed on January 22nd, 2025. And he's just filing stuff to the docket. And I think if you report on that, you probably should say this case was dismissed. Like, he literally had associated cases that were dismissed. I don't care how many new lawsuits that he files. That should also be a part of it. So, who did he? I was trying to see who he sued aside from Diddy. Oh, he only got Diddy on here, it looks like. That's the only person he had on here. So, yeah, but he sued the Department of Corrections. He sued Jay. Like, he always has somebody to sue. I think he sued in one of the other counties, one of the process servers. He said he was never served, and they're saying he got served. Like, he just didn't learn how to navigate through the legal system, and he just files stuff. Like, that's kind of what he does. So there's that. I'm just confused why they can't make him stop, or why he's not getting penalized. I don't understand why when Diddy's attorney, because he filed, I think they said, and I may be wrong, you guys probably know because I think I put it, I cut like directly, cut and paste directly from the order in my membership. I don't either, Daniel. But I think he filed at least six or seven cases against Diddy or something. And so his attorneys were asking to strike it from the docket, and also to, let me pull that up, since I haven't talked about it like that. So this is the dismissal that happened in January. I'm gonna get to you, Lil Rod, because the judge kind of went in on Lil Rod's lawyer too, Blackburn. Oh my goodness. I was like, now I've had lawyers go off on me like while we're doing oral arguments or something like that, but I've never had it in a pleading. I can't say that that's something that I've had to deal with. But yeah. Where is this judgment? Oh, here's the judgment. It's so many things after this that it's just, this docket is just so, it's all over the place. Because he keeps filing stuff. So how they're gonna stop him, I don't know. I guess in theory, they're trying to let me see something. I guess they're trying to allow him to file it. Like, how do you just say you can't utilize our legal system? I don't know. Maybe they're trying to see constitutionally if they're allowed to do it. But what should happen is whenever he files something, it should be flagged. But if every court in Michigan doesn't know that, then you're going to have the same problem. But let me see. 1 second. You could tell when I ain't been on because we just started talking about everything. So you guys just be patient with me, you know. Cardello-Smith. Did I put something in here? September 12th. I might not even downloaded it. I'm trying not to download it again because I know I read it and I ain't want to pay for it again. Let me see. January 23rd. That can't be it. This is just a judgment. Hold on, y'all. They had a whole. Is it this one? No, that's not it. Let me see. She had a whole. I keep seeing. This judge is probably sick of all of this. Like, what in the heck? So this was just filed. Wait a minute. This was filed. Let me see. I did find something else that was filed in this case. So it has before this court. So this is order denying. After he lost the case, he still filed in the same case a motion for an injunction. Like after he already lost the case. So the court has before the court is pro se plaintiff Derek Lee Cardello-Smith's motion for a prohibitory injunction to enjoin defendant Sean Combs and President Donald J. Trump from issuing a pardon or commutation to the defendant for a preliminary injunction and to order stay enforcement of the judgment of the district court while plaintiff and court resolves the issues of the amended complaint filing. The court denies as moot plaintiff's motions because the case was dismissed with prejudice on January 22nd, 2025. In its opinion on January 22nd, 2025, the court cautioned plaintiff to refrain from duplicative, frivolous, or harassing filings, including the filings of additional lawsuits related to the allegations in this case, or the filing of unnecessary papers on the dockets of cases that have been dismissed. The court warned that, quote, failure to heed this warning will result in significant pre-filing restrictions being placed on the plaintiff. It further warned that, quote, failure to heed the court's warning put him at risk of incurring monetary sanctions. Plaintiff continues to file repetitive and meritless motions in violation of the court's warning. So they got all the different ECF. Those are the different that he's filed to the docket. Those are the numbers they were assigned to. So this is after the dismissals, and he's filed more even after this order right here. The court reiterates that further violations of these warnings may result in an order enjoining him from future filings. So this should answer your question. There is nothing unusual about imposing pre-filing restrictions in matters with a history of repetitive or vexatious litigation. And then it has a footnote. Insofar as plaintiff believes he has an actionable claim against the Michigan Department of Corrections for preventing him from accessing and filing legal documents, he may file a new lawsuit. This is the person that everybody's going around thinking he wanted an injunction to stop your president, y'all's president, from pardon or commutation to the defendant. How's the court going to pre-do something to stop the president who has the executive power to pardon who he wants to? So that's that. That was filed on March 4th of 2025. Y'all think he stopped filing after that? Huh? Do y'all think so? Let's see. Let's see if he stopped filing after that. Let me stop. Let's see. I'm about to pull up this docket real quick. So that was March 4th. And let me show you all the stuff he done filed since that court. That's why I'm trying to see what she about to do. She done warned them 50 million times. So now look, that was March 4th, right? When she filed that order. We got an affidavit filed March 10th. We got the notice of appeal for March 17th. We got a motion to vacate March 18th and another motion to vacate March 19th. And he filed a whole new lawsuit. Are we really listening to this guy? That's just, I'm just asking. This is for the content creators that are really doing all these videos about this guy. Are we really listening to him? I'm just wondering. Do we just like report on anything that we think will bring traffic, regardless to whether there are real lawyers out here who he's putting out there as if they are engaging in criminal conduct, or there is a prosecutor who you're saying engaged in criminal conduct, or there's just like, this is the type of affidavits he's putting out. Are we really gonna talk about, we're just gonna talk about that? And we know there's a history. Yes, you have once somebody files something, you have a sort of defense, if you will, because it is a court document. And so you have the right to discuss it. But come on now. Y'all help me understand. Jackpot said, so that hopefully that answers your questions. That yes, the court can give you pre-filing restrictions. That's what they call them. But they warn this guy all the time, and I haven't seen it happening. Like I said, he was able to somehow file another case. And it's, I haven't read it. I didn't download it. But yeah, he ain't getting my time like that, except for the time I just gave him. So you guys know exactly who this person is. So yes, I need you guys to hit the like button, okay? Thank you so much. All right, so let's get on to our boy Rod, because some of you guys, it's been so long since we talked about him that you may not remember this case. So let's give some background. So basically, Lil Rod was a producer on the very last album that Diddy did, the Love album. And he was alleging he didn't get paid. So at first he was going around and he did a GoFundMe and he was saying Diddy never paid him. So when the Cassie lawsuit came out, I guess he said he decided to tell his story of all of the shenanigans and that he seen when he was traveling with Diddy. Remember, there was allegations against Cuba Gooding Jr. This is that case. Okay, for those of you guys that needed your recollection refreshed. And so what happened is, remember, there were UMG defendants as well, Lucian Grange, and after some back and forth and a lot of paperwork, Lil Rod dismissed UMG out of the pleading. And they asked for sanctions against his lawyer because they were saying they knew they really didn't have any claims against them, The court said that's when we first found out about the attorney and some allegations that he was filing these frivolous lawsuits or filing them in the wrong court. It wasn't frivolous. I think it was filing them in the wrong court. And the judge was saying she was going to submit him to report him to the grievance committee to review what he had been doing with filing these cases. So this is Blackburn, who represents Rodney Jones. And so Blackburn also is on the case with TD Jakes. So this case was brought, and it was a RICO claim. There was a Trafficking Victims Protection Act, or TVA, claim. There was also some other alleged sexual misconduct, and it was against his various business enterprises. Christina Coram, remember, that's supposed to be his right-hand chick. And yeah, so the court did dismiss some of those claims, but there are some claims that survived. So this case was brought by Rodney against Sean Combs, asserting a variety of claims based on his alleged history of sexual assault and human trafficking. Named alongside Combs are Combs' son, Justin Combs, actor Cuba Gooding, Combs' chief of staff, Christina Coram, his record label, Love Records, his company, Combs Global, and an unidentified female described as Young Miami's cousin. Yes, this is the one where in the footnotes, it would say a celebrity, but then in a footnote, it'd be a celebrity that used to date Nicki Minaj. You know what I'm saying? Like it was saying little quotes in there for that you basically knew who they were talking about without saying the name. Like that. This is the lawsuit for those of you that need need to be refreshed in your recollection. The second amended complaint asserts 17 causes of action, of which 14 remain. So out of 17, 14 remain. These included 2 federal claims, a RICO claim against Combs, Justin Coram, Combs Global, and Love Records, and a TVPA claim against Combs, Justin Coram, and Combs Global. So after they amended it, I guess they kept 14. And various state law claims against Combs, Gooding, Jane Doe 1, and Love Records for breach of contract, sexual assault, premises liability, and infliction of emotional distress. So the following facts, these are taken in from Jones' complaint. Again, they're all alleged. This is his rendition. This is not Pam or this platform's rendition, because I don't know these people. Type in the chat, she don't know these people. She is just reading from this good complaint. Jones' claims stem from his work between September 2022 and September 2023 as a producer on Combs' Love album. During this time, Jones lived with Mr. Combs for months, spending holidays, birthdays, and missing major family events. All of this is directly from the complaint, okay? Jones resided at Mr. Combs' residence in LA and Miami, Florida, spent several weeks on a yacht rented by Mr. Combs in the U.S. Virgin Islands and St. Bartholomew. I know I said that wrong, but you know. Bartholomew. And made several trips with Mr. Combs to New York City. Jones alleges that disturbing incidents began nearly immediately after he joined Combs' team. On approximately September 12th of 2022, Jones alleges that he was present at Shalice's recording studio in Los Angeles when Combs and Justin shot an unidentified man, and that Jones provided first aid services to the victim. Jones also alleges that he and other witnesses were pressured to hide the shooting from the police and the public. Jones alleges that throughout his time living with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching of his anus by Mr. Combs, and that he was forced to work with Mr. Combs' bathroom. I'm sorry, that didn't make sense. To work in Mr. Combs' bathroom as Mr. Combs walked around naked and showered. Combs allegedly used access to powerful individuals in the music industry, including producer Stephen Aaron Jordan, aka Stevie J, to groom and entice Mr. Jones to engage in homosexual activities, including by sharing a video with Jones of who he claims was Stevie J anally penetrating another man. In addition, Combs promised to make sure that Mr. Jones wins Producer of the Year at the Grammys if he engaged in homosexual acts. Coram was allegedly aware of and attempted to downplay Combs' misconduct and work with Mr. Combs to groom Jones into accepting a homosexual relationship. Jones alleges that other individuals in Combs' orbit committed actual misconduct against him as well. For example, on Thanksgiving Day 2022, Jones alleges that he was actually assaulted by Jane Doe 1 while he was staying in Combs' house in Miami, Florida. Jones also alleges that he was assaulted by Gooding when Combs left them alone together in a makeshift studio on his yacht. During his time working for Combs, Jones was transported from California to New York, Florida, St. Bartholomew, and the United States Virgin Island. And while accompanying Combs to these various locations, Jones was allegedly coerced into participating in commercial X acts against his will. Combs allegedly forced Jones to solicit ex workers and perform X acts and to bring prostitutes and ex workers back to Combs' home. On approximately February 2nd, 2023, Jones believes Mr. Combs drugged him and recalls waking up naked, dizzy, and confused in bed with two ex-workers and Mr. Combs. On approximately July 2nd, 2023, Jones alleges that he was present while Combs solicited ex-workers, some of which were underage, and forced them to drink liquor laced with narcotic drugs. When Jones attempted to leave, Combs allegedly forced him to stay, including taking Mr. Jones' car keys to prevent him from leaving. Jones alleges that Combs then forced him to drink the laced liquor, after which Jones began feeling lightheaded and recalls passing out and waking up at 4 a.m. the following morning naked with the ex-worker sleeping next to him. Jones alleges that Coram was intimately involved in Combs' misconduct and at times requested that Jones participate in transporting Combs' drugs and ordering ex-workers on Combs' behalf. Jones states that Combs used his power and influence to intimidate and force Jones into performing these actions. This including promising Jones a Grammy for Producer of the Year for the Love album, $250,000 to purchase all the instruments he wanted, ownership of Combs' $20 million property in Miami, and access to record label execs, as well as threatening Mr. Jones with physical harm. The threats took various forms, including threatening to eat Mr. Jones' face. Yes, you heard it, his face. Informing Jones that Combs was willing to unalive his own mother so he wouldn't think twice about harming Mr. Jones. Displaying his GUNs in front of Jones and bragging about getting away with shooting people, and telling Jones that Combs, head of security, and the power to make people and problems disappear. During the production of the Love album, Combs allegedly required his employees to consume alcohol and dismissed them if they refused, further stroking Jones' fear of what could happen to him if he told Mr. Combs no. In addition to Jones' various claims of actual misconduct, he also alleges that he was not compensated for his time living with Mr. Combs or for the songs Jones produced. Jones claimed that this violated the terms under which he was recruited to work on the Love album, which included $20,000 up front for each song he produced, 4 royalty points, credit as a producer, and for each instrument he played on the songs, and retention of publishing rights. When Jones confronted Combs about this, Combs allegedly offered him $29,000 in total compensation, which Jones refused. My thing ain't opening right. Oh, there it go. You guys ready? Those are the facts. I've been playing with this thing too long. Danielle, stop. Those are the facts of the Jones case. Okay. Good afternoon. Good to see you guys. Have you guys hit the like button? So that is the Jones case for those of you. I got my fan, law intellects here. And so now we get into the procedural history again. As I said before, this is my disclaimer. These are this man's facts. These are not my facts. I do not co-sign them. I don't know if they're true, false, or somewhere in the middle. I'm just reporting what is in this here document. All right. And the judge has provided a thorough analysis on each claim based on the face of the complaint. So what this is a motion to dismiss, and it's based on the complaint itself. That means it's not based on attached information, evidence, and all of that. It is literally based on the sufficiency of the complaint. So did he plead enough to satisfy each element to proceed to the case? Well, as you will see, the judge opined that there were certain actions that he was not able to proceed with because he did not basically in the complaint put the information in there to allow him to proceed. Okay. But there were some claims of which the judge said based on what he put in, because that's all the judge goes by is what is on the complaint. And for purposes of this motion or for this type of motion to dismiss, they assume that all the facts are true. Of course, whatever these facts are, they have to be proven later on. But this is just the initiation of this lawsuit. And so that's where we are now. Any other questions before we proceed? Any more questions? Okay. Let's go on. We're going to learn the procedures about what the procedural background is what the judge has in their opinion right now. Okay. Jones brought this action in February 26th of 2024, so about a year ago, and filed the operative complaint on April 12th. So the second amended complaint, which is what the judge is making this decision based on, or the court is making this decision based on, is April 12th, 2024. SAC stands for Second Amended Complaint. Jones voluntarily dismissed his claims against certain defendants on May 14, 2024, and the court thereafter denied a request by those defendants to impose sanctions on Jones and his counsel. Sean Combs Global Enterprise and Love Records. Then they moved to dismiss the operative complaint on August 26th of 2024 and filed a supporting memorandum of law. Quorum moved to join that motion on the same day. Jones opposed the motion on September 30th, 2024, and the Combs defendants replied on October 18th. Quorum also requested permission to join in the Combs defendants' reply brief. Quorum did not file her own motion or memo of law. So she just asked to join. Yeah, whatever they say, put me in that, judge. Just throw me in there. She asked to just join whatever they were saying, okay? Because they figured if it applied to them, it's going to apply to her too, I guess is what she was thinking. So as you guys see, the motion to dismiss was filed way back in August. The response was filed way back in September. And we just now, on today, got an order. So all of you guys that were kind of waiting on that order, we hope we get something a little bit sooner on the TD Jakes case, but it may or may not. You see how this just went, how the time frame has went in this case? This is not uncommon, okay? So then they give you the legal standard that to survive a motion to dismiss under the rules of civil procedures 12b-6, a plaintiff must state enough facts to state a claim to relief that is plausible on its face. So basically, that's the legal way of saying what I just told you guys. A claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. This means that a complaint is properly dismissed where the allegations in a complaint, however true, could not raise a claim of entitlement to relief. A complaint is also properly dismissed where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct. While threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Okay? So now this is where I want everyone to pull your fans out because it gets really hot in here. So there was already a request for sanctions against Blackburn in one of the previous dismissed defendants, UMG. And and he did not have to pay sanctions, and I did a video on it. Like he won, he didn't have to pay sanctions, even though they said you guys dragged us in this and you didn't have any proof and you're ruining our reputation and all of that. And the court allowed him to live to see another day and did not order sanctions. But this judge started out with a warning to counsel. A whole heading, warning counsel. So this is what we have. Before addressing the substance of Jones' claims, the court finds it necessary to issue a warning to his counsel, Tyrone Blackburn. I've had judges that have told me things that I was like, really? Is that what we doing? I've had judges that tell me straighten my face out because you guys know how I am. I've had judges that tell me like, relax, counsel, if you don't want to be found in contempt. But I can't say that I've had, and I don't know how it would feel if I had a judge warning me literally inside of a whole pleading that is filed to the docket. I don't know. This is a new one for me. I have not seen it. But again, I only practice here in Michigan. I'm not professing to have seen everything, but I'm just saying, this is a lot. Previously, the court declined to impose sanctions on Blackburn related to the admittedly false claims he filed on behalf of Jones against Universal Music Group and associated defendants. While Blackburn may have acted incompetently at times, the court determined that, quote, there was insufficient evidence to conclude that he had engaged in a pattern of bad faith. Blackburn also has a pending referral to the Southern District's Disciplinary Committee for his repeated failure to investigate basic elements of his case. And that's that Zembrowski v. Fisher case. There was somebody that was in my chat that said this judge was a trip. Maybe, I don't know. That's the Southern District of New York. I don't have personal experience with any of those judges. So, but they tried to basically say, and I don't know who it was, when I first reported this, they were saying that this judge, I guess, is a trip towards, certain types of people. I don't know how true it is, but that was something, again, that somebody said in my chat that I assume has some experiences, or they're alleging they had some type of experience with this judge, in front of this judge. In light of this, the court finds much of Blackburn's conduct regarding defendants' motion to dismiss to be unsettling. Blackburn's filings are replete with inaccurate statements of law, conclusory accusations, and inappropriate ad hominem attacks on opposing counsel. For example, in urging the court to consider a grand jury indictment of Combs on related criminal charges, Blackburn writes, quote, as evidenced by U.S. Attorney Williams' press conference and the grand jury indictment, defendant Sean Combs and the Combs RICO enterprise are presumed guilty of being a RICO criminal organization. That any licensed member of the bar would espouse such an absurd understanding of the law is not just disturbing, but shocking. Then, rather than focusing on the claims pleaded in this lawsuit, Blackburn writes that, quote, it is evident from the multiple civil lawsuits and the 14-page indictment the kind of actually deviant monster Sean Combs is, end quote. Both the operative complaint and Blackburn's opposition brief are full of similar irrelevant insults, misstatements, and exaggerations. See, if you're going to be shady, see, I get Blackburn because I think that he, when I look back at some of the cases I did early on, I'm like, I'm probably more cautious now than I was then, but I was so hungry and I always had things to prove to people. I didn't have these type of situations, but I wasn't scared. I took on big organizations. I did the same thing. I've had some celebrities or whatnot. But if you're going to throw a little shade in there, you just got to be a bit more discreet about it. I guess that's the best way to put it. Because it's shade thrown on both sides. All right. And oftentimes when I write briefs, I have to go back and rewrite them because I'm like, yeah, that's a bit much, Pam. Like, you just doing too much. There's times that I had to admit that I've done way too much. And I'm like, let me cross that. I ain't have to put that word up there. I have to say erroneous, ridiculousness, absurd. Like, some of that stuff, let me go ahead and not, phrase and define their argument as being as, nonsensical and not based in law and fact at all. Let me say it in a nice, a more legal professional manner, So sometimes you got to read over it. But I think because these are high profile type cases, that people like me and other people that are out here in social media that are content creators are going to read them. And so you give us these wow factors, but this is still a pleading for the court. The court has to read this. So you have to be mindful of that as well. So you might have to just calm it down a little bit, still be forceful, still be direct, still let people know you ain't never scared. But as Blackburn sees in the TD Jakes lawsuit, what they do is they'll try to use this type of commentary that the court has placed in this order, in this opinion. They're going to use it against you to say, oh, this is what he does. He's been reported. That's what they were doing. You think they're not going to try to use what this judge had to say in here? And again, in my opinion, the TD Jakes case, they was throwing a whole lot of mud, but a lot of their mud was based on the client did have a past that was kind of jacked up. You know what I'm saying? So yeah, it would have been appropriate maybe to bring up certain people that maybe Jakes has some issues with because you're doing an eye for an eye. You can't say I'm just going hard and you brought it up. I'm going to bring up all your stuff. That's something different. So you just have to be very mindful and careful if I were to offer any advice. But I ain't mad at you. I ain't telling you be scared. I ain't telling you to walk in fear because you got to learn. You're going to win some, you're going to lose some. If you ain't trying, you're not trying cases if you ain't losing at least some of them. You don't win every last one of them. There's very few people that's going to say, I tried 100 cases and I won all 100 of them. Now, you should be winning way more than you losing. But every case is not the best facts. Every case is not the best situation, especially if you do criminal. So, but let me go on. In response to defense counsel's understandable objections, Blackburn hurls schoolyard taunts at them. Writing that, quote, it is clear that defense counsel are obsessed with me, and although initially flattering, their obsession has become creepy. He put that in the court document. That's over there in footnote number 1. Oh, God. All right, let's go on. Then the court had more to say. The court has inherent authority to sanction Blackburn should he act in bad faith, vexatiously, wantonly, or for oppressive reason. Then they give they give the case law. While the court will not hold Blackburn's antics against Jones at this point, it warns Blackburn that further misconduct may lead to sanctions or to referral for discipline. Blackburn has a professional obligation both to the court and to his client to state the law accurately, to collaborate in a respectful and constructive manner with fellow lawyers, and to allow this litigation to proceed efficiently. The court will not hesitate to enforce this obligation moving forward. My goodness. So that is the admonishment against Blackburn in a whole document. I can't say I've seen this before, but I haven't seen everything. But yeah, I don't know how I would feel if I was him. But let this be a lesson learned early on. If you're going against some of these big attorneys with these big firms, you just have to be very, very careful. I'm trying to open this pop and it just spilled. Just be very, very careful how you move. That don't mean you don't have to write, professionally, add a little bit of shade, let them know that you with the ish and you know your stuff. But you also have to, be very, very accurate in what you say. Of course, federal courts, they are the ones that will look up all your cases and make sure it says what it's supposed to say. And they will look up the links that you put in there to make sure that it says what it's supposed to say. That is one thing that federal court definitely does that we don't know if state court has time to do. They got all the time. Okay. You see, they waited 4 months to even render an opinion. They take their good time. All right. So now the first that the court evaluates is the RICO. Jones' first federal claim is for a violation of RICO, which makes it unlawful to deploy the proceeds of racketeering activity in any enterprise to participate in the conduct of such enterprise affairs through a pattern of racketeering activity. To establish a RICO, this is what he would have to establish. A plaintiff must show a violation of the statute, an injury to business or property, and causation. Defendants argue that Jones has not pleaded an injury to business or property caused by such a violation and therefore lacks standing under the Act. According to defendants, the sole injury to business or property alleged is the purported non-payment for services Jones claims he performed on the Love album. But Jones alleges no causal connection between the injury and any purported RICO predicate act. Jones does not respond to this argument. And so the court basically says, I'm going to skip some of this. The question then is whether any of the other alleged RICO predicates or the pattern of racketeering activity as a whole caused defendants' failure to pay Jones under the punitive contract. The court cannot identify any such causal link. Defendants alleged X drugs and GUN trafficking activities. The vast majority of the predicate acts pleaded in the operative complaint did not foreseeably or naturally preclude defendants from honoring their recording contract with Jones. Indeed, Jones' own theory of why he felt pressured to go along with Combs' X drugs and firearm-related misconduct for so long is that he believed he would be compensated not only under his contract, but in additional benefits like securing Grammy Awards, purchasing a $20 million home, participating on future projects, $250,000 cash payments, and meeting influential music industry execs. Nor can Jones base standing on the notion that defendants fraudulently induced him to enter the contract in the first place. Because RICO compensates only for injury to business or property, A victim who is induced to part with his property by the misrepresentations of a fraudster is generally not entitled to benefit of the bargain damages, meaning recovery of what the fraudster promised as opposed to the property the victim lost. Jones also fails to plead any facts from which the court could infer that defendants never intended to perform under the contract in the first place. I'm trying to see these footnotes. So it has Jones also never alleges that defendants threatened to breach Jones' contract in order to induce him to do anything illegal. Rather, the only time that Jones mentions such threat is in connection with his request for permission to visit his family for their birthday and holidays. Okay, let's go. And Jones identifies no specific examples of fraud occurring after the formation of his contract that reduced the value of the contract or caused defendants' failure to pay. While Jones repeats the word fraud throughout the operative complaint, he appears to often do so as a synonym for illegal and does not identify any specific misrepresentations related to his contract. In sum, so this is the sum. Whether or not Jones has adequately alleged the existence of a RICO enterprise, he has not tied the activities of that enterprise to defendants, breach of contract, or any other business or property harm incurred by Jones. It also bears reiterating that Jones fails to address any of these arguments in his opposition brief, and while the court prefers to decide issues on the merits, it should not be necessary to root around a 402-paragraph complaint to contrive novel arguments on Jones' behalf. So basically what the court said is, listen, you didn't even respond to the arguments from the defense, and it's not this court's job to go through your 402-paragraph complaint and find some arguments for you. So when you choose not to respond to the specific argument that was made by the defense, even if we know that it may be an argument, it's not our job to find it. Okay, so there's that, and then there's a bunch of case law regarding that. So essentially, there's no RICO. Okay, there's no RICO. Now, TVPA is the trafficking claim. Now, that's a different situation based on the face of the complaint. Again, we're just going by the face of the complaint. For those of you that just came in, when we talk about a motion to dismiss, it's plausible facts as they are in the complaint. It doesn't have anything to do with what is attached, any future evidence, any depositions. We ain't even got there yet. So what happens is the claims that are dismissed, now, the claims that remain after the claims that are dismissed, now we're going to have Diddy and all the companies, they're going to answer the complaint. But their first responsive pleading to the complaint was to dismiss it. So they got rid of as many claims as they could, and now they're going to answer the ones that the judge says that there's a plausible factual allegations that were alleged that you may proceed. So this is the trafficking claim. Jones next asserts TVPA claims against Combs, Quorum, and Combs Global. The TVPA makes it unlawful to recruit, entice, harbor, transport, provide, obtain, maintain, patronize, or solicit by any means a person knowing or in reckless disregard of the fact that means of force, threat to force, fraud, coercion, or any combination of such means will be used to cause the person to engage in a commercial X act. Y'all get all that? That's 18 U.S.C. section 1591 sub A for those of you intellects that want to go challenge the authority. The statute does not define terms like entice or recruit, so courts have given those terms their ordinary meaning, holding that they cover conduct ranging from attracting a victim by offering something that arouses hope or desire to somehow securing the services of the victim. The term coercion is defined as threats of serious harm to or physical restraint against any person or B, any scheme, plan, or pattern intended to cause a person to believe that failure to perform an act would result in serious harm to or physical restraint against any person, or C, the abuse or threatened abuse of law or the legal process. The term commercial X act means any X act on account of which anything of value is given to or received by any person. And the term serious harm means that which would compel a reasonable person of the same background and in the same circumstance to perform or to continue performing commercial actual activity in order to avoid incurring that harm. The jurisdictional component of the act is satisfied by a de minimis effect on interstate commerce, including such minor conduct as the use of cell phones and the internet. Oh my. So the footnote, so it says Jones also asserts TVPA claim against Justin, but that claim is not currently subject to the motion. So as you will see when we get to the bottom, because I did peruse down there, it looks like Justin and Cuba Gooding were never served. So the court gave them time to serve them before, and that time has already passed. So I think the court wants to know what you plan on doing about this. So they haven't even been served, even though they're naming the complaint. The TVPA provides for civil actions by the victim against the perpetrator or whoever knowingly benefits or attempts to conspire to benefit financially or by receiving anything of value, participation in a venture which that person knew or should have known has engaged in the active violation of this chapter. Given the TVPA's breadth, Jones has adequately pleaded violation as to Combs. So he has adequately pled violations as to Combs. This is why, on numerous occasions, Combs allegedly recruited or enticed Jones to solicit and perform X acts with commercial X workers, as well as transported Jones across state and international borders in order to do so. Combs allegedly secured Jones' compliance with his request both by promising economic benefits that never materialized and by threatening Jones with physical restraint and harm. Because the operative complaint is lengthy and includes multiple examples of conduct adequate to ground a TVPA claim, the court here lists only a representative sample. So basically, there was a whole lot of facts that may make that facts that would show that there was a violation of the TVPA, but the court, these are the example the court is relying on for purposes of this opinion. On July 2nd, 2023, Jones, having traveled from his home in New York to Combs' home in California, was allegedly asked by Combs to solicit female ex-workers on Combs' behalf, including multiple individuals under the age of 18. When Jones expressed his discomfort with the situation and attempted to leave, Combs forced him to stay. This included confiscating Jones' car keys to physically prevent him from leaving. Combs then pressured Jones into drinking ecstasy-laced liquor, after which Jones recalls passing out and waking up in bed with the ex-worker. Jones has thus alleged recruitment to participate in commercial X acts, along with physical restraint and a threat of force resulting from Combs seizing Jones' keys. Jones alleges that a similar episode occurred at Combs' home in Miami, Florida on February 2nd, 2023, when Combs drugged Jones and Jones woke up naked, dizzy, and confused in bed with two ex-workers. In addition to drugging and physically restraining Jones, Combs also allegedly used verbal threats of force and fraudulent promises to induce Jones to solicit and have sex with commercial ex-workers at Combs' home in Miami. Okay. Combs also promised Jones benefits such as access to record label execs and funds to purchase all the instruments he wanted. Courts have found the making of similar promises combined with their repudiation and non-performance after the desired sex acts have occurred to constitute fraud for purposes of TVPA liability. TVPA extends to enticement of victims by means of fraudulent promises of career advancement for the purpose of engaging them in consensual or, as alleged here, non-consensual sexual activity. While some of Combs' promises, such as ownership of a $20 million mansion, were perhaps too ludicrous to be taken seriously, others, such as access to power players in the music business and help purchasing equipment, were not. So the court basically acknowledged, that saying that he was going to give you a $20 million mansion don't even sound like plausible. It's ludicrous. But there were certain things that are actually plausible. The court therefore concludes that Jones has adequately pleaded that on multiple occasions between September 22, 2022 and September 23, Combs recruited or enticed Jones to participate in commercial acts that Combs knew would involve threats of force or fraud. Finally, Jones adequately alleges that direct actual assaults committed by Combs himself were commercial for purposes of the TVPA. Jones alleges that throughout his time living with Mr. Combs, Mr. Jones was the victim of constant, unsolicited, and unauthorized groping and touching. Jones alleges that in order to entice him to accept his unwanted conduct, Combs used access to successful music producers and promised to make sure that Mr. Jones won Producer of the Year at the Grammys for his work on the Love album if he engaged in homo activities. As in the Harvey Weinstein cases, such promises constitute anything of value and are sufficient to transform the resulting X acts into commercial ones. So you offering to that he win the Grammys turns it into a commercial X act. Okay. Defendants make two main arguments. That's Combs in them. First, defendant argues that Combs' threats and promises were so outlandish that they failed to meet the general requirement that pleadings be plausible, as well as the TVPA's specific requirement that coercion be assessed from the standpoint of a reasonable person in the same circumstance. The court disagrees. So the court did not agree with Combs' argument. It's not just what Combs said that supports an inference of fraud. The context and history of Combs and Jones' professional relationship imports a degree of legitimacy of materiality to the statements. Combs is not only a successful artist and exec with extensive ties to the industry, but has a track record of winning precisely the awards that he promised to Jones. Combs also has a long history of public allegations of violence, specific instances of which Jones allegedly witnessed firsthand. Given this context, it was not unreasonable as a matter of law to take Combs' promises and threats at face value. And while Jones' counsel may be unfortunately inclined to use incendiary and salacious language, and then refers us back to the warning section, refers us up to section 3, it is not facially absurd or irrational that a powerful artist and producer would engage in actual coercion of the sort alleged here. Jones' allegations also need only be plausible, not probable, at this stage in the proceedings. Then the court said, it quotes a case that says, this is Denton v. Hernandez, which is a United States Supreme Court, that says, recalling the age-old insight that many allegations might be strange but true, for truth is often stranger than fiction. Second, the defendants, Combs and them, argue that Jones fails to provide dates for some of Combs' threats and promises, and that Jones fails to link those threats and promises to specific X acts. Defendants therefore argue that because no specific threat is causally linked to the X acts, Jones fails to establish TVPA liability. Setting aside the specific dated allegations of Combs drugging and restraining Jones to secure his compliance, defendants are correct that Jones does not connect most of Combs' verbal threats to specific X acts on specific dates. However, while a causal relationship is required, Jones' allegations suffice to plead one here. As in the Weinstein case, we talk about Weinstein a lot. The complaint must be read as a whole, not deconstructed and parsed sentence by sentence. Here, Jones provides a bounded time frame within which Combs' conduct occurred, namely the year that Jones spent living and traveling with Combs. Jones also alleges that throughout that year, he was the victim of unwanted sexual advances from Combs, along with an ongoing campaign to groom Jones into accepting such advances. Jones provides specific dated examples of Combs making threats of violence and alleges that such threats were part of the grooming process. The complaint also specifies at least some occasions on which Combs made the quid pro quo nature of his promises clear. Taken together and with all inferences drawn in Jones' favor, these allegations support an overall inference that Combs used a combination of threats and promises to secure compliance with his requests, and that those requests included participation in numerous commercial acts. Federal pleading standards do not require more precision at this stage in the litigation. So there's that. So that claim is going to go forward. Then the court talks about quorum. According to Jones, Quorum was Combs' chief of staff and was aware of Combs' actual misconduct, including his unwanted groping and touching of Jones. Jones also alleges that he expressed his discomfort from Combs' behavior to Quorum and that Quorum refused to intervene, justifying Combs' conduct by saying that Sean will be Sean and that it was just Combs' way of showing that he likes you. Quorum also allegedly requested that Jones order ex-workers for Combs on at least one occasion. Defendants do not advance any independent basis on which to dismiss Jones' TVPA claims against Quorum. It is reasonable inference that Quorum violated TVPA, so Quorum is on the hook too. She just came out and she denied all of this stuff. She broke her silence. I seen that on the internet. But yeah, this claim is going forward, and Quorum done got hit too with this claim. What y'all saying? Oh yeah, I'm gonna be reading for a minute, Kiana, and this is a 30-page opinion. All right, that was a 402-page complaint, and we went over the first complaint, and it was a little shorter, I think. But the second one, when he amended it, I didn't even go over it because I was like, no. I need to know what he changed because then I'll just talk about those. So yeah, it's very long. So what would be the point of making him sleep with ex-workers? I mean, I don't get the point. Listen. Perhaps they're saying so they can have something on him. So if they got something on him, maybe he won't tell on them. Like maybe things that people in the industry, just like Weinstein, not Weinstein, they said his name so much, Epstein, the list he had and all the people that went over there, that's information that you can always have on certain people to get certain favors. So that's what was alleged in that. So maybe that's the purpose. If I get you to participate in certain activities, then you participate in the same thing I did. Now, the problem is if you're trying to coerce somebody to do it, then that's you doing it and it's against their will. So, because if you look at Diddy, what is he saying about the whole Cassie thing? Everything is consensual, right? So maybe that's it. I'm just speculating. I don't know. Pam does not know any of these people at all. Don't know the plaintiff. Don't know any of these defendants. I only know Diddy from TV and pissing me off on making a band. That's how I know Diddy. Of course, I know his songs as well, but I don't know. I'm saying personality-wise, it's like how he was acting on TV. And I was like, yeah, no. He's not my people. That doesn't make them made up just because you didn't experience them. Elite Leo says, so I wonder in what way did he expect her, a woman, to intervene? He's a whole man and couldn't stop it or allow it to be done. Well, the fact that would you still work for somebody that you know that's allegedly doing this type of stuff? If you're watching them drug people or your job is to provide certain workers and you know that he's lacing their drinks and they really aren't consenting, how does that not make you culpable? if you're procuring some of the people to come across state lines or whatever and engage in commercial work, how does that not make you culpable? That's conspiracy. Yeah, I agree. The problem I had with this case, he's a guy, and I'm not saying things don't happen with guys, but I just never understood how he continued to go from state to state, house to house. You went to the Virgin Islands, all of these different spots, and just was begging him for your money. So he went on social media and he actually did a GoFundMe and he's trying to get paid. You went all of this time, a whole year, without getting a dollar? Nothing. You don't have a lawyer. You don't have nobody that you probably could have emailed me and I probably would have been like, nah, bro, where's your contract? And we're going to get into that on whether it was even a contract when we get to the breach of contract portion. But you get it in writing. And when you breach your contract, I'm suing you. That's how you do it. And see, the problem is when you get people that get so geeked about working with people, then you let your business acumen go to the side and you want to show you're loyal. But you better put business first. I don't care who it is. I don't care if it is Stevie Wonder. You do your business up front. Yes, it's a great opportunity. Somebody will do a feature or write for somebody like Stevie for free because of the exposure. There are times and places for all of that. But a whole year where you're basically traveling with him, that means if he wasn't paying you, he must have been taking care of you, right? Like, how were you eating? Where, you were staying at his home. How were you getting clothes? How was you getting your deodorant? How were you getting all of that? Because you weren't getting paid by him. So was it your stipend that you were being taken care of and there really was never a amount for real on how much you were going to get? You were just geeked to deal with Diddy. And I think a lot of people's business senses go to the wayside when it comes to a lot of these celebrities. And I told my clients with some contract, when I did a lot of that, I don't like doing entertainment at all. So I usually just turn it down now. But I only did it because I have friends that were getting into it. I have friends that are gospel artists, friends that are actors and actresses. And it was certain people that were notorious for giving jacked up contracts. So I would be like, okay, I'm going to look at it and tell you, I know this ain't cool. I know you should be giving up your publishing. I know you shouldn't be, like, it was just certain things that I knew that they shouldn't be doing. So this is what you do. And I know some people who have had great opportunities that probably could have skyrocketed them and put them on stages they would have never been on. But the contracts were so trash, I had to tell them, if you do this, if you blow up, you're going to be pissed like TLC because the blowing up ain't going to benefit you. You're going to have the fame and you're not going to have any money. You might have fame, but you might be doing videos talking about you living in your car, like we just saw from En Vogue. Like, you might have, though, those are real situations because we don't have our business together. So his situation, like working a whole year and not getting paid in your money, I just need more information. I'm gonna have to reach out to somebody and figure out, like, because it just never really clicked and made sense to me. I think the trouble Diddy is having is he pissed off people with his demeanor. However, pissing off people is not illegal. Lindell, I agree that he pissed me because he pissed me off. At the end of the day, he's a business person, and I think with Diddy there was a pattern. He will like get you to a position like he did with the band. I love Day 26. Like I said, the band, all of them pretty much had somebody from Detroit in it. So I liked the band. I liked when Shara Stokes was on there. She could sing. I liked old boy from Day 26. That's from here. And he was on some thing that I did, and I can't even think of his name. But yeah, like I liked all of them, and I think they were good artists. But you almost knew they were only going to go so far, and then it was going to be a wrap. So I think that, and Diddy, his attitude is not. I've been around several celebrities and they just have this aura about them of asshole. They really do. And it's like, because I remember one time I was in a situation with it was an artist and it was a concert or something, and I was doing some contracts or something behind the scenes, and they was just talking like, you just touch my shirt, like whatever I had on, you just touching my shirt like this, and I ain't, whatever maybe it was a heart shape or something type outfit I had. Don't touch me. Like, did you really just touch me? And then if you go hard like that, then it's like, yeah, I like that. Like, they'll come down like, oh, you won't play that type of stuff. Why would you be testing me like that? Like, some of them do feel like they just entitled. And it's like, and unfortunately, there are women that go to these hotel rooms that come with their panties, that climb through the windows, that do all this crazy stuff that got them feeling that way. That somebody will do anything just to be with them. Yeah, I ain't that girl. But there are people that's willing to quid pro quo just to have the opportunity. So it's going to be interesting to see how this goes. The balance of it. Should he be punished because there are women that are willing to do things to be in his presence, or to get stuff from him, or guys that's willing to do whatever just to be getting Grammys or whatever? Should he be punished for that? Or should it be like, what responsibilities do the individuals take as well? So it's going to be a balance of it, and that's going to be for a jury. Because the industry, there are people that are willing to do things to get to where they got to go. You've heard about it in the corporate industry. What do people used to say? They slept their way to the top. To me, that's taking advantage of the woman too, right? Because why would you do that with them, knowing they don't really care about you like that? They just know that they're gonna stay sweeping floors if they don't sleep with you in order to get to where they gotta go. So it's a lot. It's a lot. Groupies have been around forever. Even Jesus had groupies. They have been. They definitely have been. So it's interesting. Like I said with Lil Rod, it was like, after a while, he just stayed so long that it was like, so eventually what made you get out? The album was done. So you was like, and you waited until he discarded you, or you just kept going in hopes that eventually it's going to pay off. And then a month turns into another month. Then it turns into 2 more months. Then it turns into 3 more months. Like, this is going to be interesting to see, especially if he has a deposition and the deposition ends up being attached to one of these pleadings and we get to read it. You said I can't. Me neither. I can't afford to work. I've had opportunities, and sometimes celebrities, even with lawyers, they be feeling like you supposed to be geeked that they came to you, and they like, you give them a bill and they like, huh? What is this? Your bill. What are you talking about? And then they get mad because you charged them, and then they go someplace else. That's fine. I'm not working for free. I don't care who you are. You can be the president of these here United States. I'm not working for free. I don't care. Are y'all hitting that like button? Huh? Are y'all hitting that like button or no?
And another thing you notice, the first thing they say, make sure you guys hit that like and the subscribe button. That's what it's all about. After they get them dogging you out, before they dog you out, that's the first thing they say. If you like this video, make sure you hit.
You have 1 minute remaining.
So my question is, Elite Leo, is yeah, okay, he kept going until the album was finished, but you didn't get nothing up front before you started traveling with him. Anybody that does like I'm gonna say artists, when artists go and someone books them to perform, you get some upfront money. You gonna at least get half, and then you get the rest of your money before you hit the stage. So I'm not saying that when it comes to points and all of that, you have to have that in writing. Like, I think he's alleging that he told him he would get certain points. So that means he'll get royalties on certain songs that he helped write or co-wrote. But that's writing. You don't go into anybody's studio without split sheets to say what percentage everyone gets. They have like the Nashville splits where it's like everybody's going to be equal regardless. But somebody might come in and they the hook queen or the hook king. So you know they're gonna do a hook. What is that worth? Is that worth 30%? Is that worth 40%? Do we think the hook actually makes the song? You come in we can't start. When you're in a studio, you don't even let people in there. I don't care if you the janitor. If you ain't a part of this split sheet, you get out of here, because what you're not gonna do is come back and say you helped write this song. Don't bring your homeboys in here. Like, there is etiquette to writing and all of that. All my clients I had, they don't get played because I put them up on game immediately. So I don't understand, like, it's, and this was recent, like in the last, what do you say, 22, 23? This ain't no back in the 90s. You know what it is. And it's hard to even get paid now because everything is streaming. You don't make money like you used to, even with writing. Writers have been protesting because they don't get paid the way they should now. Writers used to be where the money resided. So Elite said he had free housing, utilities, and food for 3 years. That's what I'm saying. If he wasn't getting paid, then that means somebody was covering you in other ways. I've been thinking, said, doesn't he have a child? How was he supporting his child during this year if he never received any payment? All great questions. Great question. Lindell said an example would be Kato Kaelin has been doing the same interview on the topic of O.J. Simpson for 20 years. How else would he be relevant in the entertainment world to make money? That is true. I mean, he may have just had to find something else, find some other way. He just so happened was able to do it as being friends with, what was Kato Kaelin? I know he's part of the O.J. situation. Was he friends with like Nicole or something? I don't remember. So anyway, Combs Global got dismissed from the TVPA conduct. It does not allege that Combs Global, the corporate entity, directly enticed recruited. So they didn't get hit with that. Accordingly, the allegations failed to support a reasonable inference that Combs Global benefited from any participation in trafficking ventures, and Jones' TVPA claim against Combs Global is dismissed. So Combs Global, they got to win on that one. On the TVPA, they also got to win on the RICO. So Combs Global is winning right now. The state tort claims. In addition to his federal claims, Jones asserts a variety of state law tort claims based on incidents of actual misconduct that allegedly occurred while he was living and traveling with Combs. Although defendant's misconduct allegedly occurred in at least 3 states and 1 foreign jurisdiction, no party addresses choices of law in their briefs. Applying New York choice of law rules, the court determines for now that the relevant law for each of Jones' tort claims is the law of the state where the tort occurred. So actual assault, of course, Jones asserts a claim of actual assault, which the court construes as a claim for assault and battery based on actual conduct against Combs. Combs' only argument against this claim is that Jones fails to allege sufficient factual details, which both provides insufficient notice of the claim and renders plaintiff's claim implausible on its face. While Jones does allege in general terms that Combs continuously touched and groped him throughout their time living and working together, Jones also alleges specific instances of unwanted actual conduct. This includes Combs drugging and sleeping with Jones at Combs' Miami home on February 2nd of 2023. Such allegations, at least some of which include specific dates and description of X acts, are sufficient to provide defendant with adequate notice. Okay, so Jones' allegations are sufficient to state a plausible claim under at least Florida law, which imposes civil liability for the threat of offensive actual conduct or the intentional infliction of such conduct. The court thus declines to dismiss Jones' actual assault claims as to Combs. So Jones has won on the actual assault claim, and that will go forward. Emotional distress. Jones asserts claims for negligent and intentional infliction of emotional distress against Combs based on the same conduct underlying his sexual assault claims. Jones fails, however, to adequately plead a required element of those torts, severe emotional distress. Regardless of which substantive state law governs Jones' claims, that element is required and must be pleaded with specificity. So what the court did, they used the different elements for each state that he's saying it was alleged in. So nobody talked about the choice of law, which means the actual what state's law should be applied. And so the court opted to, if it happened in Florida, we're going to use Florida law. If it happened in New York, we're going to use New York law. So that's what they're doing here. So that he didn't state severe emotional distress. Here, Jones merely recites the elements of the tort throughout the operative complaint without providing further detail as to the nature and extent of the emotional suffering he has experienced due to Combs' actions. And while Jones includes a few additional details in his opposition to the motion to dismiss, that's a bunch of parens. Jones' intentional and negligent infliction of emotional distress claims are dismissed. So intentional and negligent infliction of emotional distress are gone. So Combs won that. Premises liability. Jones also asserts claims of premises liability against Combs based on the alleged sexual assault committed by Jane Doe 1, which was Young Miami's cousin, and Goody. Defendants. Has anybody, Young Miami be doing interviews, has anybody asked her, like, girl, who is this cousin that was on the boat? That would be my question. I want to know, who is this alleged cousin? Is this true or false? But she's still Jane Doe, so apparently they don't even know who she is. Defendants argue and Jones concedes that Florida law applies to the incident involving Doe and that Virgin Island law applies to the incident involving Gooding. In both jurisdictions, premises liability is a subspecies of negligence and thus requires a plaintiff to plead duty, breach, causation, and damages. When such dangers involve criminal acts committed by third parties, liability requires that the offender have been actually or constructively known to have a dangerous propensity. Both Florida and Virgin Island law also require that there be a special relationship between the parties for a duty to prevent third-party misconduct to arise. Okay. Regarding Doe, this is the cousin. Jones alleges that the assault occurred in Combs' house, meaning that Combs had both possession and control of the premises. Jones also pleads sufficient facts to support a reasonable inference of the existence of at least two special relationships, landowner invitee and employer-employee, as Jones was working under contract for Combs at the time of the assault. And even though Jones does not allege that Doe had a known history of committing sexual assault, he alleges that Combs witnessed Doe attempt to straddle and have sex with Jones while laughing and encouraging her to continue. Jones also alleges that Combs was aware that Doe was assaulting him in the bathroom while it happened and that he did nothing to intervene. Together, this is sufficient to permit the reasonable inference that Combs knew or should have known about her propensity to commit actual assaults, and that he violated his duty to prevent her assault on Jones. Combs invokes Florida's impact rule, which generally bars pure claims for emotional or mental damages unless the plaintiff sustained a physical impact from an external source. An unauthorized, Accordingly, Jones need not plead in detail his physical or emotional injuries to survive a motion to dismiss. Regarding Gooding, the situation is similar. Jones alleges that Gooding's actions should have been foreseeable to Combs as Gooding pleaded guilty to a misdemeanor charge based on sexual misconduct in 2022, among other publicity reported instances of similar misconduct. More importantly, however, Jones alleges that Combs intentionally left him and Gooding alone in a makeshift studio on Combs' yacht after suggesting that Gooding get to know Mr. Jones better, along with Jones' allegation that Combs was grooming him by frequently suggesting that Jones engaged in homosexual acts. This supports the plausible inference that Combs foresaw and enabled Gooding's alleged assault of Jones. Combs responds that Gooding had only been accused of assaulting women, not men, making his assault of Jones unforeseeable. But it is not implausible as a matter of law to think that someone who has assaulted members of one sex in the past is more likely to assault members of other sex in the future. Combs also argues that because he chartered the yacht on which the assault occurred and was not the yacht's owner, he cannot bear premises liability. Jones acknowledges that the yacht was rented by Combs for several weeks, not owned. The court disagrees with Combs for two reasons. First, Combs cites only Florida law for the proposition, not Virgin Island law, which he can see governs Jones' claims concerning Gooding. Unlike Florida, the Supreme Court of the Virgin Islands has held that in all premises liability actions, the touchstone in the foreseeability of harm and not the labels attached to the plaintiff or the defendant, it has rejected the use of outdated and formalistic distinctions pertaining to ownership or possession of property or chattel. Oh, Jesus. Okay. Because Gooding allegedly engaged in unwanted sexual contact, Jones need not plead detailed physical or emotional damage stemming from the contract. The court therefore declines to dismiss Jones' premises liability. So Jones' premises liability claims are going to go forward as well as of now. Then we get to the breach of contract. So for those of you that don't know, this is what started all of this madness. All of this started because allegedly there was an agreement to hire Jones to produce on this Love album, and Diddy took him all over the world, subjected him to all of this different stuff that he just can't shake, that he'll probably need therapy for the rest of his life, is what he's basically alleging. And he ain't even paying. He did not pay him for his work, is what is being alleged. So that's the breach of contract. And like I said, originally, he had a GoFundMe of which he was trying to get his money from the GoFundMe. And so let's see if his original issue the court allows to go forward. Finally, Jones asserts breach of contract claims against Combs and Love Records for failure to compensate him for the work on the Love album. In a contract case, New York courts will normally apply the law of the jurisdiction having the greatest interest in the litigation as measured by the jurisdiction's contacts with the litigation. However, as with tort claims, the first step in any choice of law analysis for a contract claim is to determine whether there is an actual conflict. Here, defendants maintain and plaintiff concedes that there is no such conflict. So the court applies New York law based on Jones' residence in New York. Under New York statute of frauds, any contract that cannot be performed within 1 year is unenforceable unless it's in writing. You learned that in contract in law school. That is something that you learn in law school, and I think that is pretty universal in most states. If you have a contract that cannot be performed within 1 year, it's unenforceable unless it's in writing. This includes an indefinite agreement to pay royalties like the alleged contract at issue. See Andrew v. Sony Music, where it held that New York courts have specifically determined that open-ended oral agreements for the payment of royalties are subject to the statutes of fraud. And under New York law, an oral agreement that is void under the statute of frauds may not be severed to save an otherwise enforceable agreement. Jones fails to respond to this argument, other than by arguing that all of the songs composed by Mr. Jones were completed in less than a year. This is irrelevant, as it is defendant's portion of the contract that could not be completed within a year, not Jones' portion. Because the oral agreement is subject to the statute of fraud, Jones' contract claims are dismissed. So all of this was about you not getting paid. And then because it was not in writing, in conformance with the statute of fraud, you wasn't going to get nothing anyway. So basically, Diddy has to deal with all of this because you kept this person around, and they allegedly are saying they seen, and they also were subjected to various activities, unwanted activities, drugs and sex and GUNs and everything else. But at the end of the day, you would have got you a free producer because Diddy is a business person. You think he did? So when he offered you $29,000, you probably should have took it. Why? Because it wasn't in writing, and you wasn't gonna get nothing if you didn't take it. So yeah, there's that. So that is what the court is saying, that claim is dismissed because apparently there's no contract, is what it looks like. So let's go on. Guess who gets to get blocked? You, Benny Hill. You get to be blocked. Congratulations. Because I don't block very often, but you win the prize today. So this is the last part about the other defendants. On September 9th, 2024, Jones filed a letter with the court requesting an extension of time to serve defendant Justin and Gooding. The court granted the request and directed Jones to serve those defendants by November 8th of 2024. Jones has not since notified the court that service has been completed. Accordingly, Jones is directed to file a letter with the court explaining the status of service as to Justin and Gooding within 2 weeks of the date of this opinion. So he has 2 weeks to show what is going on with serving Cuba Gooding Jr. and Justin. Should Jones fail to do so, the claims against those defendants may be dismissed for insufficient service or failure to prosecute. Jones has also not yet served Jane Doe 1, but has provided no explanation for his failure to do so. The court therefore dismisses Jones' claims against Jane Doe 1. So it looks like Young Miami's cousin is off the hook. Alleged cousin is off the hook. Conclusion: for the foregoing reasons, the Combs defendant's motion to dismiss is granted in part and denied in part. The motion is granted as to Jones' RICO claims, negligent and intentional infliction of emotional distress claims, and contract claims. So 3 of the claims are dismissed. The motion is also granted as to Jones' TVPA claims against Combs Global. The motion is otherwise denied. Jones shall file a letter within 2 weeks of the entry of this opinion explaining the status of service as to Justin Combs and Cuba Gooding Jr. Jones' claims are dismissed as to John and Jane Doe's 1 through 10 and ABC Corporation 1 through 10. Defendants who have been served shall file an answer to the surviving claims with 14 days after the date of this opinion, and that is that. So that is the long opinion of the court on the Jones matter. Do we have any questions? We've been on for almost 2 hours. Do we have any questions? Where did the raids take place? So it was in a couple of Diddy's houses. I think it was Florida and California. Remember, Kato was living in O.J. Simpson's guest house job was to begin with. Okay, got it. Yeah, I can't. That case is so old. I don't even remember. And I was so young at that time, too. All right, I don't see anything else on here. So thank you so much for renewing, Stacy, for that first twin. I appreciate that. And thank you, Mina said, for becoming a member. I appreciate that as well. So if you guys don't have anything else, we've discussed Derek Cardello. So I'm going to have to change the thumbnail so I can add him on there. And we also discussed Jones. So that's that. Until next time, I guess, make sure you guys hit that like button. Subscribe to the channel so we get back in this good algorithm. And welcome to everyone that's going to watch it on the replay. And that's it. Thank you guys for hanging with me and rocking with me. I appreciate it. The reason I asked that is because he was charged in New York. Well, there were things that happened in New York as well. Allegedly. It's all alleged. He is innocent until proven guilty. And again, I don't know these people. All right. I'm going to get a shirt that say, I don't know these people. Not one of them. I don't know what's true and I wasn't there. So there's that. Of course, Brenda Brown, thank you so much for listening and supporting the channel. But I'm out of here. I hope you guys enjoyed. And until next time, I'll holler at you.